Welcome to this new lesson of political science for the class 11 CBSE syllabus. In this new lesson, we will talk about the fundamental rights as enshrined in the Indian Constitution. You must have heard before you started reading the books, you must have heard that Indians have what is known as fundamental rights. We will talk about another important right here, the right to freedom of religion, because you know that India is a land of religions and there is no forced atheism. Atheism means unbelief, not believing in God. The government of India does not force anyone either to believe in God or not to believe in God. So, all individuals have been given the right to freely profess, practice and propagate their religion. Profess means to say that an individual, he or she, belongs to a particular religion. Practice that religion. What is practice? Practice is based on rituals. Every religion has its own set of rituals and certain doctrines. So, you believe in those doctrines and practice those rituals. So, you practice a particular religion and propagate religion, and there has been a controversy regarding this propagation, and there is a Supreme Court verdict which you must find out as students, and that propagation does not mean conversion. Propagation, there is a particular English term, propagation means evangelization. Evangelization is what? To preach one's religion. Now, preaching is generally done by many religious organizations with the objective of converting one. Converting means to make people leave their ancestral religion and join another religion. So, certain religious organizations believe in propagation for the purpose of conversion or proselytization. The Supreme Court has ruled, and as I told you, you must find it out as students for yourself which year and which verdict of the Supreme Court it was that the Supreme Court interpreted propagation as not including conversion. So, apart from that, the profession, the practice and propagation of religion, Indians have the freedom to manage their religious affairs and the freedom from religious instructions in certain educational institutions. No Indian can be forced to take religious instruction, and here you must know that religious instruction not only belonging to another religion, religious instruction of your own religion as well. No Indian can be forced to take. Generally, people make this mistake that religious instruction means religious instruction of another religion. No, religious instruction of one's own religion is also included in this. So, articles 25 to 28, 25, 26, 27 and 28, and as I told you, individually you should go through the articles to see what is there in what. Next, we will look at certain cultural and educational rights that the Constitution ensures, the Constitution guarantees for Indian citizens, that the cultural and language groups have the right to preserve their culture, language and distinct script. Preserve that script, preserve that language and not to be dominated by others. In India, there have been incidents, there are instances of people of a particular language using the script of another language. For example, in Manipur, they earlier used the Bengali script. So, that kind of thing was there in India, but then if a particular language has a script, then that script and that language both, the preservation of both is guaranteed by the Constitution. And the rights of minorities, religious and cultural minorities, to establish and administer their educational institutions, the educational institutions of their choice, and that is guaranteed by Article 29 and 30. So, all these are guaranteed by these two articles, and there shall be no state interference if a minority wants to establish and administer certain educational institutions in which the religious instructions that I was talking about, in which those religious instructions are given to students. There shall be no state interference in that. The last important right, even though it is not the least important right, is the right to constitutional remedies. The right to constitutional remedies means that the Constitution itself has made certain provisions for taking recourse to if one's fundamental rights have been violated. If an individual sees or understands that his or her fundamental right has been violated in any way, either by the state or by other individuals or organizations, then the right to move the Supreme Court itself is a fundamental right. This you need to understand. Right to move, I repeat for your benefit, that right to move the Supreme Court for the restoration of fundamental rights if they have been, if and when they have been violated, that right itself is a constitutional right. And even though I have mentioned Article 32 to 35, it is actually contained in Article 32, where moving the Supreme Court is a fundamental right that an individual has if one's fundamental right has been violated. And the Supreme Court gives certain writs, certain directions to the government, to lower courts, to institutions for the restoration of an individual's fundamental rights. Writs in the nature of habeas corpus, mandamus, certiorari, quo warranto, and prohibition. So, as students, it is your duty to look into what the writs are and when the writs are applied by the Supreme Court. I tell you just now that the writs are actually directions given by the Supreme Court to either the government or to lower courts for the restoration of an individual's, an aggrieved individual's fundamental rights. So, there have been important deletions and additions to the list of fundamental rights, means that not all rights that were there in the original Constitution exist today as fundamental rights, and there were many which were added later. Two come to mind, and that those two rights are very important. One, the right to property. The right to property was a fundamental right till the 44th Amendment Act of 1978 removed it as a fundamental right. It exists as a legal right today by Article 300A. On the other hand, the Right to Education Act of 2009 made free and compulsory education for children aged between 6 and 14 years a fundamental right by including Article 21A in the Constitution. So, these two are important additions and deletions to the Constitution of India, to the fundamental rights as given, as enshrined in the Constitution of India. The most important question, and I will end with that, can the fundamental rights be tampered with? Can they be maneuvered? Can they be done away with? Can any government try to delete those fundamental rights from the Constitution? The answer is a resounding no. Fundamental rights cannot be removed, fundamental rights cannot be modified by any government. There was a case known as the Keshavanand Bharati versus State of Kerala, 1973. We generally know it as the Keshavanand Bharati case. The Supreme Court of India held that Parliament's power to amend the Constitution, even though the Parliament's power is wide, that power is not unlimited. It held that the fundamental rights were part of what is known as the basic structure of the Constitution. It developed the basic structure doctrine. This judgment, this verdict of the Supreme Court, the Keshavanand Bharati case in 1973, in which the Supreme Court developed the fundamental right, the doctrine of basic structure, saying that fundamental rights formed part of the basic structure, and Parliament does not have the right, it does not have the power to alter the basic structure, even though its powers, just as I told you, it admitted, the Keshavanand Bharati case, the Supreme Court admitted that the power of Parliament to amend the Constitution is wide, but even then the Parliament does not have the power to alter the basic structure of the Constitution, and fundamental rights are part of the basic structure. Furthermore, the Supreme Court held that any legislation that seeks to alter the Constitution's basic structure, that legislation means law, that legislation drawn up by Parliament will be struck down by the Supreme Court as unconstitutional. So, no law, Parliament cannot try to alter the basic structure of the Constitution through any law, and as I told you that Parliament is a law-making body. So, the Supreme Court reserves the right to strike down any law that in its opinion tries to alter the Constitution's basic structure. The Supreme Court will strike down that law as unconstitutional. Now, the basic structure doctrine, it was further evolved and reiterated by the Supreme Court in the Minerva Mills versus Union of India case in 1980, but then the first time that the Supreme Court got involved in the matter of protecting fundamental rights from parliamentary amendments, the first time was in 1967 in the Goloknath versus State of Punjab case, better known as the Goloknath case, in which the Supreme Court ruled that the fundamental rights were beyond the Parliament's amending power. That was the first time. Now, in the case of Keshavanand, the Keshavanand Bharati case went beyond this Goloknath case by evolving the basic structure doctrine. It says that basic structure, there were many other things in the basic structure. Fundamental rights are a part of basic structure. Secularism is part of basic structure, federalism is part of basic structure. So, fundamental rights is also part of basic structure. So, the basic structure in its entirety cannot be overruled, cannot be altered, cannot be modified by the Parliament. So, the Supreme Court went beyond Goloknath in the Keshavanand Bharati case, and this basic structure doctrine, it was reiterated by the Supreme Court in the Minerva Mills case in 1980. I hope that you have learnt about the fundamental rights considerably as part of this lesson. What are fundamental rights? Why are they fundamental? In the first place, what are rights? Why are they in the Indian Constitution? Where are they in the Indian Constitution? And what is the role of the fundamental rights in the lives of Indian citizens? In a subsequent lecture, we will look at the so-called conflict between fundamental rights and the directive principles of state policy, and trace how the Constitution of India has tried to negotiate this so-called conflict. Thank you so very much for listening.